Welcome back to this course on copyright and related rights law. This week, we have already discussed term of protection. By now, we are all very clear on the kind of term of protection that applies to subject matters of copyright, to performances, to broadcasts. We have understood the distinction between application of publication and of making of the performance and the making of the work and the making of the broadcast. In today's session, we are going to understand the consequence of the end of term of protection, which is public domain, and we are also going to consider the voluntary giving up of copyright by a right holder. Let us look at the first portion of our discussion today. In this first portion, we are considering the question of what happens when the term of protection expires. You would recall we had discussed that, for instance, a literary work such as a book which has been published during the lifetime of an author, where the author is identified as the lifetime of that author plus a period of 60 years counted from the beginning of the calendar year next following the year in which the author dies. What happens after these 60 years have expired? We understand that the work then enters the public domain. We must understand what public domain is, and towards that understanding, let us recall our discussion from our first session. In the first session, we had discussed the incorporeal nature of property, in which I had explained that quite like land on which fencing can be done to keep unauthorized personnel outside, similarly, copyright erects an artificial fence upon which lies the question of whether a particular act has been authorized by the copyright holder or not. This question of what happens after the expiration of the term of protection can be answered by considering this artificial fence when we say that at the point of expiry, that this particular fence no longer exists, meaning that all kinds of authorization which copyright offers would now be free for use for all members of the public without any such requirement of an authorization. Therefore, what is public domain? Public domain, as we understand, is that all economic usage which is otherwise covered within a specific provision of Section 14 under the Copyright Act, unless it has been accepted under Section 52 or other provisions under the Copyright Act, now there is no such requirement of any authorization under Section 14. Let us also ask whether the expression, the fact that it is now in public domain, let us also understand that in respect to public domain, if a work is entering the public domain at the expiry of a term of protection, can it also be stated that a work is in public domain if no copyright subsists in it? Clearly, that is possible. And therefore, public domain and the entry into public domain of an expression, we can understand, would happen in two ways. One, that the expression which has been generated, this expression, even though it is not copied from anywhere, but because this is not original, the expression is in public domain. Copyright doesn't extend to it. And second, that copyright did extend to a particular expression for which the Copyright Act provided for a specific term of protection wherein there was exclusivity to the copyright holder. After the expiry of this term of protection, now the work has entered the public domain. It's free for use for any member of the public. Now, consider, what about usage without authorization of the copyright holder during the subsistence of copyright? You would realize that what we were discussing was a question of what happens after the term of protection has ended. But during the term of protection, if any use of a work has to be done without authorization of the copyright holder, it can only be done through recognized form of exception, which is permissible under the Copyright Act. This is something which requires its own detailed explanation and understanding, and something that we will look at in the following sessions in this course. Therefore, in terms of the use without authorization from the copyright holder during subsistence of copyright, it would be a question of an exception which is permissible under the Copyright Act, and once the term of protection has ended, then there is no exclusivity of usage anymore. This is not a question of an exception against an exclusive right. It is no exclusivity and free public usage. Now let us consider that if public domain means that a work is now free for use to the public, is this not possibly something that an author might want or could want? So, in a scenario where the author does not wish to exercise his copyright, would it be possible for the author to simply give up his copyright? Give it away? Not exercise it at all? It should be possible. The question is, if in fact this is something which can be done, is there a specific manner in which this should be done? And is there any specific consideration that we must keep in mind when thinking about such a giveaway? Anything serious? We must understand that whatever the reasons that a person may wish to give up the copyright in a work, there is a serious consideration that any such right holder must keep in mind, that the giving up of copyright is a huge giveaway. It is but a practice which has been seen through the form of contract in the industry, that authors and performers as well, without a complete grasp on what they are giving away, tend to engage in such giveaways of their work for free. We will attempt to understand this giveaway in terms of what it means in copyright terms, and then come back to the question of what the process is for the purpose of giving up copyright protection. You would recollect that we had discussed at the time of discussing assignments and licenses that such an agreement between the copyright holder and the user can be restricted in both duration as well as territory. So, in terms of what copyright is, we must understand that although the term copyright is used in a singular sense, the actual number of copyright is reflective of this particular expression, which is often used with respect to copyright, that copyright is a bundle of rights. There is an inherent plurality in the singular usage of copyright, meaning that we cannot just say simply that I'm giving up my copyright. Rather, the better way to understand this is to understand the real plurality of the application of copyright, which for instance can be seen through a reference to Section 14 of the Indian Copyright Act. We have referred to Section 14 many a times over the course of this particular course on copyright. You would have seen that our reflection on Section 14, that Section 14 has come up in various discussions on a variety of topics. In this specific consideration, we are looking to understand how copyright is not a singular right, but rather a bundle of rights, which, as you can see under Section 14, as the author of a literary work would enjoy, not just the right of reproduction, but also the right of issuance of copies, the right of adaptation, the right of translation, to make a cinematograph film, to make a sound recording, to make a performance of the work, to communicate the work to the public. These are all rights which the author has an exclusive control over. To say that an author is giving up his copyright, whether there is a sufficient consideration of the seriousness of what is being given away, needs to be clearly understood. Let us consider, for example, issuance of copies, which is a copyright within the bundle of rights. Now, issuance of copies, because this is connected to distribution is looking at territory. Territory can be split. So, an entity which is having the logistical capability to distribute a particular work in, say, the state of Rajasthan can be considered for the purpose of this particular right. Similarly, there can be other entities in other territories of India who can be considered for such a license. In terms of the duration for which such a responsibility has been given, that duration can also be limited. So, in terms of each state in India, there can effectively be a different distributor for distinct durations who have been authorized by the right holder. You would question, what is the relevance of such a consideration of duration? It's important to understand that the limitation of duration helps the right holder in understanding efficiency of logistics, performance of the assignee or the licensee, and where such performance is not satisfactory, even consider non-renewals, considering another party for the purpose of carrying forward that issuance. But in terms of purely the monetary worth of what issuance of copies is, if you look at that, copyright over a particular work is not limited to just India. Copyright extends to many countries in the world. Therefore, any such giving up of just this one right, which is issuance of copies, is to give away the copyright across territories and across any such durations. Let us consider another example. Consider a cinematograph film. Say the author of the copyrighted work is the script writer, the work is the script. How many films can be made from the same script? There can be n number of movies that can be made on the same script. you would realize that by giving up the copyright in a script, any such possibility of a separate cinematograph film being made on the script is effectively given away. Therefore, the author will give away the revenue stream which is technically possible coming in from the usage of the script for different films. Similarly, consider sound recordings. How many sound recordings can there be based on the same composition? There can be n number of sound recordings. To then just give up copyright on the composition is to give up all of this revenue. It must be kept in mind that copyright doesn't only extend to the lifetime of the author. As a kind of property, it vests with successors of the author. And therefore, in terms of the economic impact that copyright has from its plurality of application under Section 14, to give up copyright or to relinquish copyright is to consider these serious points and only then take a decision, because relinquishment cannot be undone. Once copyright is given up, there is no mechanism to bring it back. It is now effectively in public domain. Having understood the kind of seriousness that the issue of giving up copyright must be given, let us now look at the manner in which the Copyright Act is providing for relinquishment. You can see under Section 21, the Act says that the author has a right to relinquish his copyright. It says the author of a work may relinquish all or any of the rights comprised in the copyright in the work by giving notice in the prescribed form to the Registrar of Copyright or by way of public notice, and thereupon such rights shall, subject to the provisions of subsection 3, cease to exist from the date of the notice. As we have seen, the usage of the expression all or any is a reflection of a careful consideration that authors can make with respect to the extent of copyright that they wish to relinquish. If the extent is to cover all the rights under Section 14, then that too can be done, but there is no way that once there is a relinquishment that the copyright will somehow come back to the author. Let us also understand that relinquishment by the author is subject to subsection 3 of this provision. Imagine a transaction that the right holder has entered into with another party, meaning thereby that the copyright under Section 14 has been transacted by way of an assignment, for example. In such a situation, would the independent act of relinquishment of copyright by the author have some effect on the assignee? If yes, then it would be wholly prejudicial to the assignee. Therefore, Section 21 Clause 3 provides a safeguard. It states that the relinquishment of all or any of the rights comprised in the copyright in a work shall not affect any rights subsisting in favor of any person on the date of the notice referred in subsection 1. We have thus understood that from Section 21, it is clear that there are two ways in which relinquishment can occur. One is by the way of submission of a form. This specific form is Form 1, found within the first schedule of the Copyright Rules 2013, and by way of a public notice. What a public notice is explained within the chapter dedicated to understanding relinquishments, and the procedure in such relinquishments under the copyright rules. Rule 5 explains public notice, wherein it says that it means mentioning of notice on the work or cover of the work, or publication in one issue of a daily newspaper in the English language having circulation in the major part of the country, and also in one issue of any daily newspaper in the same language of the work, or posting the notice on the website of the Copyright Office at the request of the author by giving the details as required under Sub-Rule 2. This is Sub-Rule 2 of Rule 5. Let us take a look at it as well. It says, the author relinquishing the rights under Rule 5 by giving public notice shall include in the notice the details as given below. Class of the work, title of the work, full name, address and nationality, language of the work, name, address, nationality of publisher, if published, with year of publication and country of first publication. If copyright in the work is registered, then the registration number, the right or rights to be relinquished, and the date of relinquishment of the rights. It is very clear that any such notice, any such action of relinquishment must be through a specified process, and through this process, any person who is looking to relinquish his copyright will understand the implications, the seriousness, and will have time to think that what he is giving up is something that he does want to give up, either in some portion or in its entirety. If this sufficient consideration is not backing the act of relinquishment, it can be disadvantageous to the author. In the next session, we are going to take a look at reproduction right and the issuance of copies right, and an issue which is connected to issuance of copies, which is parallel imports. Thank you for joining me. See you all in the next session. Thank you.